Friday, January 17th. And this morning, we're going to get an update on implementation of Act 180 involving pre-charge diversion. And we'll start, actually, Willa Farrell, if we can start with you, since Tim has disappeared, and I was going to start with you anyway. I was going to rearrange our order of witnesses. So if that's okay, and if you identify yourself for the record and proceed, thank you.
Good morning. My name is Willa Farrell. I work in the Attorney General's office. My title is Court Diversion and Pretrial Services Director. Would you like me to just dive in?
Yes, absolutely. Okay. Dive in. Explain. We have 3 new people, and we have others who need reminders of what we did with 180 and how it's going.
I thought I might start very briefly, if I might, just talking a little bit about the Attorney General's office and how we support community-based programs. So I'm within the Community Justice Unit. I'm sort of focused on the newer members of the community. Within the Community Justice Unit, we support 12 organizations around the state. They all provide the same array of services. And all of these services are outlined in statute. So many of you probably are familiar with court diversion, which has been a program under the AG for about 45 years, longstanding alternative to being prosecuted through the court system. We also have a program for civil violations of underage alcohol and cannabis possession, which is a similar alternative to getting a ticket through the Judicial Bureau. And then more recent additions include our DLS program. DLS is driving with license suspended. And that's a program both for criminal as well as civil violations where people can learn, or really basically are helped to navigate the system and identify what do they need to do in order to get their driver's license reinstated. And also helping people develop budgets and put money aside to pay for their requirements. And this committee has done a lot of work on DLS in the past few years. And a more recent addition is pretrial services, which is a set of services for people who are going through the criminal justice system, helping people to connect people to services, primarily mental health and substance misuse treatment services. And it's not a restorative justice or alternative program. It's really more health-focused social service type set of services. So these are all services that happen prior to anybody's adjudication in the criminal or family division. And we provide an annual report, which provides some data and other information about these services. I'm happy at any time, of course, to talk more. And the one piece I'll just add is around those principles that underpin the work we do. So we rely on risk, need, responsivity principles. Really briefly, like lower risk folks, we're going to do less with them. And higher risk, then that's where there's more intensive services and more support. And restorative justice principles. Some of our services are truly a restorative justice alternative where people are coming together, those most directly affected and involved, to come up with a plan to repair harm. And those principles of like engagement and respect and really having the most people who are at most affected involved in programming underpin other services, even if they're not truly an alternative to a criminal proceeding. I will segue back now into last year's Act 180, which addressed what is called pre-charge or direct referral from law enforcement. So historically, the Department of Corrections has supported in their grants work being done by community justice centers to work with people who've been referred directly by a police officer for sometimes, many times, an actual crime, but that has not been charged by the prosecutor. And that has existed of mixed degree around the state. For various reasons, this aspect of pre-charge diversion has now in Act 180 come to the Attorney General's office, and it has been codified. So now in statute, there's actual expectations about timeliness of outreach to victims, having a program manual, reporting data to the legislature and others about the work being done. That codification really builds off what we're now calling post-charge court diversion. And programmatically, the work will be very similar, a restorative justice process. There's a significant difference in terms of the legal ramifications for an individual. Pre-charge by statute now is a crime, but it has not been charged by a prosecutor. So it has not yet entered the court system. And there are a couple of benefits to this. One is it's much faster. Can be a really fast, timely response to an incident. Victims can get served more quickly. We know sort of like deterrence is often tied to the rapidity of response. And so there can be a much faster response to what happened. And I'm thinking about court backlog. It also keeps a number of cases out of the court system. To date, pre-charge has varied around the state, both programmatically what's happening and whether it exists at all. And that stems in part because there hasn't been a structure, I think. And also the existence of pre-charge is really going to be driven by each county state's attorney and their policy about as they direct law enforcement in their community. Act 180 required state's attorneys to post those policies. So and I'm sure my colleague Tim Leaders-Dumont will speak to this. So I'll just say that those policies are now available for people to see. During the past year, it's really been a year of preparation for our office and for the current providers. Presents a big change, both to codify and have different standards and expectations, and also to have a new grant administrator that works differently. Also in Act 180 is an expectation that our office would fund one organization per county, with provisions about how to reach that goal. In a few counties in Vermont, there are multiple organizations or different organizations that have historically provided pre-charge diversion and post-charge diversion. In some counties, it's the same organization, so it's not as dramatic a change. Those organizations are familiar with our manual, or already have coordination in-house around those services. So during the past year, I would say there's two aspects of what I've been working on. One is just the program development. What is pre-charge diversion? So I've been learning a lot about what currently exists. And we will be developing a manual in coordination with providers and other stakeholders. I've shared our current manual for court to post-charge diversion with folks, but frankly, I haven't had a lot of capacity to work on developing a pre-charge manual. I just started to talk with current post-charge diversion, these are mouthfuls, post-charge diversion providers about, well, what's different? How would pre-charge diversion look? How would it be different from post-charge diversion in your mind? So we're starting to have that conversation within the Association of Post-Charge Diversion, many of whom already do pre-charge. Becomes a bit of a jigsaw puzzle when I talk about this. Act 180 also tasks the Attorney General's office with coming up with a plan by April 1 in counties where there is more than one pre-charge and post-charge provider to streamline the provision and administration of services. So the counties I've been having those meetings really are Chittenden County, Washington County, and Windham County. I will say that Chittenden County is where there is the most pre-charge activity in the state, there are probably on average 400 to 500 cases handled pre-charge. In Windham and Washington County, it's like 40 or 50 a year. And in some counties, there's no pre-charge, but we expect that to change because state's attorneys have now issued policies saying, this is how I envision pre-charge. I'll just say those conversations are challenging. Change is difficult for people, and we're asking people to consider how to work differently, how to move towards a more streamlined system. And it's not, I want to note, it's not, yes, I think there could be some administrative savings and more resources going into delivery of services, but it's not just that. It's also like, how do we coordinate with post-charge diversion, with the other programming that is happening all before adjudication? And how do we ensure people are getting the right services and not working with multiple case managers? We will definitely have a plan to the legislature by April 1st with any, I think we might be able to get you plans prior to that. Whatever we come up with, there's certain priorities, and that is to ensure that services continue to function and operate, that they are embedded in local law enforcement agencies where they exist now, and that we build on those successes, make sure we have timely and high quality services. I was also asked to speak sort of about high level overview of what's next. And I think it's really continuing this work of the streamlining conversations and program development as much as we have capacity at this point. I was also asked to note anything that we need from the legislature policy wise or budget related. There are a couple of more housekeeping requests I might ask, and I could provide more detail later, but I know this committee is not going to talk about sealing. I just note that the record deletion components of Act 180 have some administrative asks of our office that I think are not necessary, given that the information is confidential. So depending where and how that might be best to be fit in, I would share that with.
It sounds like the kind of thing we could put in our miscellaneous
Yeah.
bill, which is starting actually in the Senate.
Okay.
But we'll get it and we'll be adding things.
Okay.
After crossover. So it gives us a little time to make sure what we need for that.
Great, thank you. And I think there might also be of a similar nature, some help to cross-reference in the juvenile statutes in 33 VSA, the juvenile pre-charge diversion, just for clarity. Again, I think more of a housekeeping ask. The save the best for last, the resources that we need. So in Act 180, there is a position for our office to help with the development and ongoing delivery of pre-charge diversion. I would say that this is a much needed resource. Our office has been asked to take on a lot of work over the years in this realm, and we are stretched thin. So we need that in order to do what is asked in Act 180, to actually have a program that is consistent statewide and that ensures that providers receive the support and that we do our due diligence around grant management.
That's in the Budget Adjustment Act is where
Yes.
that ask is.
Correct. Our office has spoken with Representative Squirrel about including that position in the budget adjustment. Of course, none of this will happen unless there is funding for the providers to do the work. And Act 180 actually names that it's contingent upon funding. The bill was passed last year when there was funding from the Department of Corrections for existing providers, but not for expansion. Our office is putting together a proposal for the House Appropriations Committee to fund to maintain existing services and to provide staffing so that we can have services in throughout the state. And at the estimate at this point is about 1.75 million. It's a difficult budget to anticipate without knowing how, what will be the demand, but also just the reality of having a need for a certain amount of staffing to be available to respond to what happens and what may grow. I also, yes.
Karen,
Okay.
I just don't know if you've shared what the implementation date is when we're supposed to see everything start.
July 1. Thank you, Representative. So yes, this is the idea, is that we're making this transition right at the end of the fiscal year. And the lack of just the uncertainty either about funding per se or even like approximate amounts makes it very difficult for current providers, some of whom are based in municipalities who already may have their budgets for town meeting, not knowing. And for the nonprofit organizations who, have working with their boards on budgets for next year. Our office, I might just back up for a minute. In the state budget, if you go to the Attorney General's office line, you'll see a line for the AGO, which includes all, 150 people and the full array of the work done by the Attorney General's office. Then you'll also see a line that says court diversion. So it's separated out. The monies that our office grants to the 12 providers is a separate line item in the budget. And that has helped both our providers and us to know this is the amount, this was appropriated last year. The odds are it will be a 3% increase or whatever the governor's instructions have been. And so programs have been able to anticipate that they will at least have as much money as they had last year. But we don't know that. We don't know what was, we're starting at a place of uncertainty, which just adds to the complexity of the conversations. So obviously we'll go into more detail with House appropriations about how we came up with that figure. But that is our estimate at this point.
we may have you run that by us as well as
Okay.
we give a recommendation
Okay.
when we get to the budget process.
Right.
Yeah, right now it's on the BAA and we're going to be weighing in on the BAA as well.
Okay. Okay, great.
But that's
Yeah.
shorter term.
And I also just want to note, while this is not in our office, in the act, is a recognition of people going through pre-charge diversion, having the opportunity to consult with a public defender if they have questions. And that the Defender General's Office has shared with this committee last session their anticipated need to provide that service on a contractual basis, as I understand. And I do think, given the newness of this program, that would be an important resource to ensure that participants who are referred have an opportunity to consult with an attorney if they have questions. So I believe that's my high-level overview. Happy to answer, of course, other questions or provide more information.
There are other questions? Go ahead, and then Angela, I think.
So it sounds like, well, first, thank you for all the work that you've been doing to get this up off the ground. I know it's been a short timeline with a lot to do in it and without the position. So thank you for that. So good to hear that the request is out there for VA for the position and that working on the funding request for the budget. Does that also include, I'm sure there needs to be funding for the position as well?
Yes, that the funding for the position would fall under the Attorney General's Office budget, not the line item that's labeled court diversion is solely grant dollars.
Okay.
Yes.
Great. So that's part of it too. So if we can work on those pieces, do you feel set that the program is going to be ready to start July 1st in whatever counties are ready to have it?
Right. I would say how I envision this working, because we're working with current providers, already, or let me back up, providers who are currently doing the work with other funding, or where there is not pre-charge, we have relationships with organizations doing post-charge court diversion. And from the point of view of a victim or somebody who committed the crime, the experience will be similar. So, and this is me speaking off the top of my head, Representative Dolan, that there would be a transition. I don't anticipate that July 1, law enforcement in any one community would be making multiple referrals, that there would be a process of explanation based on the state's attorney's policy and whatever the state's attorney has done prior to July 1. State's attorneys will be well aware of budget developments, as will we in the months leading up to July 1. Our grants would be issued, being realistic, probably not until mid-June, unless based on when this body finalizes the budget. So new staff would not be on board July 1, but I anticipate working with providers about how would we segue and ramp up to staffing and service delivery. So that's a long-winded way of saying, yes, we'd be ready, and it would be a little rocky. It would be a transition. It would be an iterative developmental process.
I have another question. It came up I forget who shared it when we were going over juvenile justice stuff, that I think it was Judge Davenport said that training for law enforcement around restorative justice to help to get referrals. This is just in general.
Yes.
But will that be, so I guess this is two questions in one. Is there an RFP planned for delivering the grants, or is it just delivering grants? And will law enforcement training or outreach, I'm just trying to think, how are law enforcement going to know and have those relationships to make those referrals? So just two questions in there.
Our office is not planning to issue an RFP.
Okay.
In terms of law enforcement training, our current providers and existing pre-charge providers have strong relationships with local law enforcement. We already provide the Youth Substance Awareness Safety Program, which is, those are violations that law enforcement make the direct referral to the program. And obviously, state's attorneys have very close relationships with both law enforcement agencies and our providers. So I think the explanation of a new system is already, frankly, those conversations are happening to some degree now. And I think they would be an ongoing process supported by our office, but really grounded locally between the state's attorney's office, the provider, and police chiefs and barracks leaders about what does this new system look like? How does it play out in our county? And in some communities, those conversations are happening currently.
Angela, and then Tom.
Karen covered my question.
Okay, Tom.
Oh, welcome back. Is it, or maybe we've covered it before, is it envisioned that pre-charge is going to stop or intervene in the actual charging of the subject? Is that what the hope is? Or will that, they'll complete pre-charge and get consideration because of pre-charge?
The concept is that if somebody completes the pre-charge program successfully, then they would not be charged. And if somebody fails the pre-charge program, then that case could or would be charged. And I say could or would because I think it would depend on the state's attorney and what their original policy is. Some state's attorneys are involved in the decision to make a pre-charge referral, in which case I'm assuming they would be more inclined to make that referral.
One more follow-up. Are you aware of anybody's participation in anything pre-charge and then particular failure jeopardize their criminal case?
I'm not aware.
But that's why they would engage with counsel, hopefully prior to.
I'm sorry, Representative, would you mind repeating the question? Make sure I'm answering it correctly.
If somebody is engaged in pre-charge
Yes,
and their engagement as a result of that,
yeah,
and then potential failure in the pre-charge
Yeah.
jeopardize them later.
oh, in a substance, a different
Right, yeah.
charge. I'm not aware of that, but it certainly seems like it's possible.
That's why we would want them to consult potentially.
I assume that Tim might be able to weigh in on that when we have him testifying as well. Ian,
Yeah, thank you very much for your testimony. Just a quick question kind of off of that. Is part of the plan that's coming out for April 1st about the administration of this and how much, like how similar it's done from county to county as far as like how much state's attorney is involved in sort of the discretionary part of this and how much of it is just law enforcement? I'm just sort of curious if you could speak to it.
So we won't, the degree to which state's attorneys are involved in decisions about pre-charge really depends on that state's attorney's policy. So that's really up to the discretion of the state's attorney, how they wish to see pre-charge implemented in their community. So our plan would be more about from the perspective of the funder and the sort of administer on a statewide level, how do we see meeting the plan of streamlining administration and delivery?
Do you review the policies of each of the state's attorneys for each county as to what their sort of goals are with free charge diversion?
I mean, I've read them and I talk with local providers about how does that play out in your county? And sometimes they'll say, oh, look at this interesting piece here when, maybe you should talk to your SA about that and, try to like share the cross-pollination of ideas. But the actual policies are, to set by the state's attorney.
And then just final question. So come July of 2025, do I understand that actually hearing what you said before, that's not going to be quite right away, but like, is it going to be Chittenden, Washington, and Wyndham County where we'll see this start based on the conversations you've had?
Those three counties are where there's what I would call somewhat significant amount of pre-charge currently. So in those communities, there might not be much difference for like a law enforcement officer. It would just be, they might not even know that the funding stream has changed. It's more in communities where now state's attorneys have issued a policy and are saying to law enforcement, I would like you to use this tool. And here's the provider. They now have funding and please now do this. So that's more the July 1. And there's certainly in some of the providers we work with now have told me, I keep getting these calls from law enforcement. I want to refer pre-charge and they'll say, well, we don't have funding to do it yet. And, please wait. So those conversations are happening.
Yeah. Thank you.
You're welcome.
I'll just comment on, so this was one of those situations where we had geographic consistency and discretion of individual states attorneys. That was a big part of the conversation this past spring and really came out that the discretion was important. And I think largely we looked at various policies and they're not significantly different. Is that safe to say? I mean, it's so we've reserved the deterrence, the deference, and yet it's like, I think the practices are relatively consistent. And then Tim can talk about that as well. So.
Yeah, and I would just say, I'm sure that, a question, like there was a lot of discussion about it and like coming in as a new member and not having been on this committee during that. I appreciate that.
But I know it came up just yesterday as far as that the discretion versus geographic consistency and justice. And this was one that was front and center earlier this year. But I think we landed it quite well.
And I would say that from our perspective, like what we're aiming towards is that when people do come to a pre-charge program, whether as a victim or somebody who committed a crime, that you have a similar experience, that there's a certain amount of consistency in program delivery, and like we're going to reach out to you in the same 5-7 days, where you're going to get the same information about your rights and responsibilities. You're going to have a restorative process that people have, had similar training. So that's, I think, also really important, is that the actual services have a certain consistency. And oh yeah, that's really where our goal is.
Other questions? Thank you very much. Thank you.
Thank you.
Thank you.
Tim? I know that surprised you that we actually were right on time. Yes, which that's the first time in this year. So
No, good to see everyone. And yes, I'm back. Not for most things you'll see Kim, but this one I said Kim had all these all other parts of the job that you all don't see, including public records and charge codes and other things that I said today, you can get caught up on that, as I'm distracting them for a couple of hours now. I'll be very brief today, actually. But Tim Leaders Dumont, Department of State's Attorneys and Sheriff's Executive Director, and prior to my recent position there, I was the legislative attorney, worked on some of this over the last couple of years. And I was also a practicing deputy state's attorney in Washington County. Last year I said Washington, or yesterday I said Washington, and people thought I was talking about something in Washington, D.C., because I'm Washington County. Whenever I say Washington, I'm talking about our Washington County. But I practiced in Washington County and was essentially the diversion liaison for the two CJCs, one in Montpelier, one in Barrie. And then the post-diversion office, it's like good to clarify all the language that we're now using, and have also recently redefined some of how we're using language. Is really important, because parochial, the use of language in practice that state's attorneys might have used in the past, like pre-charge, direct referral, things have been codified in a way that wasn't always reflective of how it's used in practice, but we're getting there in terms of how the legislature is talking about these things as well. So sometimes you will change wording here, and then it'll take time for it to sync out differently in the community in terms of the practitioners that were doing work. 2 years ago, when I was sitting here doing the chair said, walk folks through the system from basically zero to, if there was 20 stages to the intercept, I'm looking at, well, we got to stage 25, post-conviction relief and appeals and sealing and expungement, the whole. But if you look at that presentation, which was posted on your website last Friday, you'll notice that I used pre-charge before it was a bill, before anything else, because we were doing the act of, now not talking about the defined term, the act of referring things prior to the filing of a charge across the state, right? And we're still doing that. So even though the codification and the funding and all of that is sort of great, what are you going to get when you get to a diversion office? That's what's being worked on, and the great work that Will is doing, and I know Rachel and the team of folks across the state are doing as well. That codification in terms of what people get when they walk into a diversion office, that's what's happening now. But the act of exercising discretion, first, law enforcement sometimes can do it in their own. Looking at my friend over here to the right, but state's attorneys as well. Sometimes they get an affidavit, or they get a phone call, they get a case review, and we say, send it to the CJC, or as we will say in the future, looking at Willa, send that to the diversion office, and they can do the whole thing at some point, right? They can do pre-charge, they can do post-charge, they can do the other programs. So just, if you look back at that presentation, early in the sort of series of intercepts from a couple of years ago, I was talking about pre-charge, because I often utilized pre-charge when I would get a call from a law enforcement officer. We use graffiti example somewhere in downtown Montpelier. Sometimes, right, I know it has no chance of getting through the court system and having a trial because of the backlog. And I would say, try sending that to the CJC and inform them that if they're successful, and we usually would talk about a time frame for that, that we won't file charges. But I've got a copy of sometimes it would not, I wouldn't call it an affidavit at the time, but sometimes we had a copy of the finding of PC, probable cause. And, it was a very fluid improvisational process, and that will still happen with any utilization of discretion. And it's important to have that local discretion. Judge Davenport has also said previously, a number of years ago now, that the reason we have differences in the communities is because of the different resources that we have in the communities as well. So sometimes a lack of referral isn't a lack of initiative or interest in a referral. It's because there wasn't an opportunity for that referral to actually land somewhere. So getting to kind of where we're at with Act 180, We are on our way, well on our way to compliance with Act 180 in terms of the publication of policies. I will say there's been 9 published policies of the 14 at the moment. The one in Washington was the prior policy. I posted it on the website just because some law enforcement officers were trained under that. That's the one I used, and it's a helpful model. But I noted on the website it's the prior policy. So there's some counties, like for example, I know Orleans has a piece of paper they're working on with their local folks, and that's very close to getting done. Windsor County, same thing. Franklin County, same thing. They're kind of right on the verge. So by July 1, I hope to have full compliance. I've helped many of the state's attorneys that didn't have a written document, that policy that we're talking about, get there over the last 6 months or so. And that's been a good process. And we did cross-reference many of the other policies. Some of them had practices, pre-charge practices, or community referral practices. Those are the 2 distinctions you put in the bill last year, if I'm saying it is a community referral. So the pre-charge is defining a PC now, probable cause, which could result in a crime, a criminal code filing happening. Community referral, you guys put the distinction in there last year that's no PC is required. That could just be, basically a suggestion that they go to the CJC or the diversion offices of the future. So if you look on our website, you go to prosecutors.vermont.gov, you go to resources. There's a long list because of the way we talk about things. CJC, pre-charge, RJ, I put a bunch of the ways that people talk about this stuff, so it kind of captured it on there, but you'll see a list of the policies that we put up there. And I just wanted to note that, just because I wanted to start first with your question, Representative Dolan. Right now, we don't have any training staff in the Department of State's Attorneys and Sheriffs. We train ourselves in terms of the state's attorneys, but we don't have any dedicated training staff. We don't have any restorative justice full-time staff. Like I said, sometimes there's a liaison deputy that works with a local office. That's kind of the go-between. Often it's the arraignment attorney. Sometimes there's an attorney that kind of does the weekly arraignments like I did in Washington. And so you just develop a natural relationship with, in my case, it was Meg Rizzo in Washington County. And we would be talking all the time prior to, during, and after arraignments about where different folks were headed with diversion. And so we don't have dedicated training staff. So that's something that, I'm looking at Representative Squirrel, and we've been in his committee already this week. But that's something that if there is that interest in us actually going out and going into each of the agencies and departments and educating them on the policies, that's something that at this point, right, we have 96 pending homicides, 23,000 pending cases in our system. So we're going to do our best as always, but that's something if you have an interest in, talking with Representative Squirrel, I will say if there's anything beyond what Act 180 requires of us, like there was an expectation of real granular training, that would be a resource question that we would have to talk about. But right now, we're not resourced to go out and do proactive law enforcement training on pre-charge. We do the best we can with the other realm of after of post-charge, really. But just wanted to flag that. I hadn't contemplated talking about that today, so it was a good question. The other one I wanted to just note is that right now, when I was hearing Willa, she was talking about essentially DOC's data collection of pre-charge. I'm going to say something, I hope it's not controversial. That data is incredibly inaccurate, and it's not anyone's fault. I'm just going to say it's not accurate, right? So in Windham County, Tracy Shriver, the former state's attorney, used to, I'm looking at from Windham County, used to have these days, RJ days, where they were pre-charge days where they would go to the local RJ office, and if you engaged in essentially rep board type of thing that day, charges were never filed. I don't know if data was collected for that. And part of that, from her perspective, was we're keeping the data out of the system because we're keeping these folks out of the system. So that's that balancing point of wanting to have good data for people that go through the offices so you can all make good calls on resource allocation and help resource Willa's operation, but also understanding that the data is pre-charged. So you are creating data points for people that we're trying to keep out of the system. So how you collect that data will be important to keep de-identified or whatever. I know you've talked about that last year, but we know we have examples in other counties as well where the act of a referral prior to the filing of a charge has occurred, but it didn't create a data point that DOC then collected. So there is referrals happening prior to the filing of a charge that is not currently being captured by data. And so we would, right, I know that's going to be probably part of the manual. When someone walks in the door, how do you collect that data point? Was it a community referral? Was it a pre-charge referral? Did they walk in on their own because they had a conflict with a neighbor? And often sometimes we would literally say, hey, you've had a conflict with this person who's your neighbor. Law enforcement has gotten involved. There's no crime right now. But to mediate that situation, we have a local place here in Montpelier or in Barrie, and the county was split into a number of towns would be served by the two CJCs. Go try to sort it out, because otherwise it gets into that elevated level where we have to put post-charge resources. But you'll see in that training that I did a couple of years ago in 2023, these are all just the pathways and the options to divert. And in Vermont, I'm happy to say we have a lot of pathways to divert right now. It's up to you to resource them, but we do have options, and we are exercising those options. Even in places that, without naming any counties, that you might not expect a pre-charge referral has occurred, we're trying to alleviate what we're dealing with on the other side. So we do not have an incentive. We have enough cases. We do not have an incentive to like pile on. It's the moral hazard is the other direction for us. Again, I wanted to say by July 1 is kind of we sort of looking at the statute. That's what we see as the deadline to get all the policies posted. I will say a recent policy that is a good kind of barometer for how some of the state's attorneys are talking with each other about this is the Rutland policy. It's also, our state's attorney that came on board in 2022. So kind of a state's attorney that's been there for a few years, getting settled in a really good data-driven office. And so that, for some of the other offices that haven't adopted yet, they may be looking to, like in Rutland, for example, to see how to work on their policies. And again, prosecutors.vermont.gov, you can see resources and click down there. I didn't want to flood your committee page with those, but they're all on our website. Yeah, any questions for me? Have I missed anything?
Appreciation for all the work that you did with this. So I am on the website now and seeing all those policies, and I appreciate you saying that some of these were things that were already in motion, but now it's documented. And also to hear that we're like leaning on each other, be like, what's in your policy? Like,
yeah,
I would just say it, getting to that geographic equity is just nice to be able to pull up and see what is the policy in my county, so I know what it is, and then to be able to get like, oh, that's different from how it is in there. So there's appreciation for the work for getting that up there. And
I think you struck a nice balance last year of, we had lots of conversations early on, and I think the bill struck a nice balance of codifying and protecting the local democratically elected prosecutors, but then also once the referral happens, making sure that your funding and the administration of that programming is something that you all can understand and have consistency. So I think it is a good balance. And the state's attorneys at all SA meetings, I remind them to, talk with each other, talk with me. I helped draft a couple of the ones that were in there. I am proud of some of the work that they've done on these. And the other thing is that state's attorneys have 4-year terms. So typically these will be good at least for 4 years in terms of, you all have 2-year terms, so stuff changes sometimes, but 4-year term is nice in terms of the community understanding what's going on. But the other side to the coin, and I was talking with Chief Burke last year about it, I remember, is there's certain communities that are really used to working with their local CJC or, future diversion providers. And there's other law enforcement office agencies that are not as used to that. And so that's a dynamic, right? That, state's attorney can put out a policy, state's attorney can, if we have training resources, do some trainings, et cetera. We can certainly train and work with our sheriffs because they're in our department. But in terms of municipal agencies that have select board or town or city manager that is telling them, here's how your job is going to work in this community, they might be getting direction adverse to Act 180, depending on that agency. And while we can put out a policy and we can help, we can say yes or no to affidavits and yes or no to charging. That's the discretion, the gatekeeping that we do. Two things. One, sometimes it leads to adverse relationships with law enforcement agencies when we do not proceed with charges that they've worked on and investigated with a finding of probable cause. That's just a relationship thing that I wanted to point out. And the other piece is if they're self-motivated to do the referrals, which a lot of the policies actually encourage law enforcement type referrals, then that's kind of your best case scenario. Last year, you had two state's attorneys in here who agree on many, many different things, but they had different takes on should state's attorney be super involved? Should the law enforcement agencies be really involved? And then if something goes awry, then it can come up to the state's attorney's office. So there's that balance. And I think the whole act is kind of a balance that you all struck, and where it landed last year did not overly burden us, the policy and the publication piece. But in terms of rollout, that's going to be the next phase, what rollout looks like. But the last thing I'll finish with, because I started with it, is the referral of things prior to pre-charge has always existed and will always exist. This is a helpful new way to think about it. So from my perspective, talking with the state's attorneys, there are, even a declination, we decline, law enforcement officers say, oh, I still want to do something with this, right? They might still do a referral of some sort on their own. So that sort of thing is interesting as well. Another kind of footnote of how we are engaging with this work. And Erica Marthage talking about juvenile work. She's had a pre-charge, pre-petition, not charged, pre-petition program in Bennington County for the better part of 2 decades. You heard from that provider last year. And that's been very successful to divert truancy cases, divert low-level delinquencies, and sometimes even catch a chins type of filing before it gets to a chins. So she, at some point, if you want to talk about juvenile stuff, she could talk about the success of that program in Bennington, again, not captured by DOC data. So yeah, any questions for me?
Questions? So I just, so I know that we don't have Judge Zone to talk to this, but he wouldn't have a lot to say, except he did, I know earlier this or last year when we took this up, did call this out as something that could help with the backlog and just help us keep some cases out of the court. I mean, is that your experience as well?
Well, it would be good once I will say 2 years from now, once excellent data practices have been installed and we know how many cases are truly being referred. We do live in a fairly small state where there's no large border walls around our counties, thankfully, but people engage in all types of activity in all parts of the state. And so because the majority of our dockets as of last year were individuals with repeated criminal conduct with filings, it may help, but we still have the existing backlog, which is not just COVID related. That is our true backlog. Yeah, it could help with future things if there's a large amount of buy-in.
I guess I shouldn't even say backlog. It's so that I get too caught up in the talk of backlog. What the real talk is how swift and certain consequences are, or more accountability is.
And if that's
really the issue,
it will help. And again, I know Willa talked about the speed. I have experienced different things in referring something prior to the filing of a charge. One type of experience is it's quick, swift. You get an email back in 30 to 60 days. It's great. Other times you think you're going to get an email back in 30, 60 days because it's not on your docket, because it's not staring you in the face. You get an email back 6 months later or 9 months later, like, this thing got lost. It's really not appropriate for me to file this misdemeanor in criminal court because yes, they failed out, but I didn't get the notice of it until 9 months later. So that consistency of notice back.
So hopefully the process that we're putting into place will help
with that. Yeah. Yeah. And Rachel can talk about how they've done it successfully in Burlington for a number of years too.
Appreciate it. Any other questions? All right. Thanks.
Thank you all. Good to see you.
So we're going to see you next Thursday, right? You're going to come in for the public.
Oh, so that's going to happen next Thursday? I put a big bookmark on that.
Yeah. You'll get an invite.
I may bring State's Attorney Sullivan with me, my data guru.
Yeah, no, that's great. Cool. Great. So that's exactly the kind of things we want, kind of much like the hearing that we had last year.
Good to see you. Get that over.
Good morning, everyone.
Morning.
For the record, my name is Rachel Jolly, she, her pronouns. I lead the Burlington Community Justice Center, which is a division of the Community and Economic Development Office of Burlington. So I've been asked to represent 21 centers who receive state funding to operate a variety of programs using restorative justice within the criminal legal system. These programs and services are offered in every county throughout the state, with the exception of pre-charge diversion, which has only been offered in a few counties thus far using DOC funding. Act 180, of course, is trying to address this. And it's because there are a few new members of the committee, and also I just want to reiterate some things that you've already heard from Willa, the value of pre-charge being this expedient case resolution. That's best for the victims in terms of them getting contacted early in the process and getting more some of their questions answered, if their choice, if they want to engage or not. Keeping cases that should be kind of upstream and keeping them that way instead of having them go further into the system is generally a good thing. And the codification, this idea of more oversight, management, and policies that are transparently talked about in print for the community to see, and this very much based in community. I mean, I think that's what we are aiming for in terms of keeping the programming that has happened already in some of these counties, keeping it as local as possible with the law enforcement and the community provider dealing with the case. So I also want to talk about one of the benefits of restorative justice is accountability with multiple parties, even though society in general has linked accountability with punishment and coming from the state, there's a variety of needs in the variety of misbehaviors that we have going on. So this isn't necessarily to replace one with the other. It's not that restorative justice is always the right solution and that punishment is never the right solution, but it's trying to diversify our tools around dealing with very diverse kinds of behavior. So I do just want to always stress that restorative justice is a form of accountability, and I invite anybody to observe a process, compare it with a trial or an arraignment, and see what kinds of accountability is asked for from the person responsible. It's very high on accountability for those who do engage. And again, it's not right for everyone. We've been hearing a lot about repeat offenses or some of the cases where mental health and substance use are very dominant factors. Pre-charge wouldn't necessarily be right for many of these folks who are repeat offenders. So I just want to say that but one of the benefits of Act 180 is that we are trying to really sit down in a transparent way and codify what are the appropriate cases, have some uniformity about the way it's played out, and also have more nuance for the other certain kinds of cases. So I will speak to something that Tim Dumont just talked about, which is the community referrals. So yes, pre-charge has been happening in a variety of counties in different ways with DOC funding, starting in fiscal year 26 with the RFP that they just released that is due later this month. That is no longer pre-charge, and these community referrals will no longer be covered by the Department of Corrections funding. So that does leave, we still have an unknown there, not to mention the Act 180 funding for pre-charge diversion. That's an unknown, but the community referrals so far wouldn't have a funding. So it's still of a question. The agencies that have taken those, maybe a crime hasn't been committed, but there's some wrongdoing that wouldn't have made it to court and shouldn't, but could that CJC or that agency deal with it? Now this is more of a question to be answered. So I just want to point that out. And as you can imagine, there's a diversity of voices within the 21 centers, given a variety of histories and our funding sources. So I can best speak for my own center, but I also can summarize what has happened in Chittenden County since Act 180's passage, some of which you've heard in summary from Willa earlier. So there are 4 community justice centers in Chittenden County, all of which have historically received Department of Corrections funding, and one of which, our center, the Burlington CJC, receives AGO funding. So we have been working with the county. I will just kind of take this time to say too, in terms of the question about training, is all of the diversion and pretrial service contract holders and providers do have that relationship with our law enforcement because of the Youth Substance Awareness and Safety Program, YSAS. And some of us too, who have been doing pre-charge, like in Chittenden County, have very close relationships with the PDs in terms of offering our own trainings. And a couple of years ago, we did get a contract with the Department for the DCF, Department for Children and Family Services, to offer RJ training around the state to law enforcement providers. So that was the beginning of something that we then shared with all of the CJCs to say, this is the curriculum we use. You could use that too. I just want to underscore that I think we are one of the best to provide that kind of RJ training, maybe that rather than from the state, in terms of having the local partnerships already in place, and then can use our own on the ground experience with doing restorative practices to offer it to law enforcement. So in Chittenden, the AGO has, as you heard, led a series of transparent conversations and meetings that involve CJC directors, town managers, chiefs of police. And I've appreciated the spirit in which the AGO has gone about that, to really involve the folks who have been doing this work, sometimes for decades. In Chittenden County, we have been offering pre-charge for decades, and talking about a variety of scenarios for the future. At this point, obviously, especially not knowing funding, there's still a variety of unknowns, and the biggest of which is funding. I do think that kind of is paramount. So obviously, you've been hearing it from Willa, and you'll hear it again from me. So, and with the release of DOC's RFP, which is moving to regionalization, they have been funding 17 centers across the state. They're now going to be moving to funding 13 as of July 1st. We don't know what funding, if any, will be allocated for pre-charge diversion. And so the agencies are swirling in unknowns. In Chittenden County, we have been offering pre-charge for 400 to 500 cases in a year. And so funding really is what would be most useful. So this would be our priority request, that to identify dollars that could be used to support this important and community-based service that has been successfully running in a few counties, and that is a critical piece in reducing court backlogs and streamlining our systems.
Sure.
Sorry, just to clarify, thank you for the update of it. The DOC piece that you mentioned, that they put out an RFP requesting funding from one entity per county. That is something new, and that's not associated with Act 180. I just want to make sure that's clear.
Right.
That's completely
And it's
separate.
essentially one agency per county, although there's going to be 13 allocations, despite being 14 counties. Yeah.
Okay. So that just that came up. That was not part of this.
Yes,
That's
it happened to be parallel tracks. But it's pertinent because, again, DOC has funded pre-charge, and as of fiscal year 26 will not be. So Act 180 has, AGO will be funding it, but in the midst of some agencies' reliance on DOC funding, this is just a mix of unknowns that happen to be at the same time.
So I'm going to ask one of those questions where we make a statement and ask if you agree.
Okay.
So 400, 500 cases a year. If we're not funding the 400, 500, the CJCs to do the 400, 500 cases a year, a good number of them, not necessarily all, because some maybe they just won't charge, but a lot of them are going to go to the court, where it is actually more. You're going to confirm whether I'm remembering all the testimony I've had on this. It's going to go to the court where it's going to cost the government more money, and we're going to not necessarily have the accountability come as swiftly.
Yes.
Is that correct?
I think it is correct. From what I understand from our state's attorney, even the fact that they're going to the state's attorney in the first place, if they can't in our county, because given how long we've been doing it, some of these are not going to the state's attorneys first. Most of them are not. They're just being handled by we have MOUs in place.
And that definitely happens.
Yeah, we have very successful MOUs in place that are very clear about what kinds of cases are appropriate for pre-charge, what are not. And so they can go directly to the CJC, precluding the administrative costs of even going to the state's attorney and entering them all in their system. And then there's be some that would be probably not maybe dropped, and then some that would be charged, and then absolutely added to that, to the court costs. And so in every way, it would be more expensive. And in some ways, in many ways, it would be more time consuming.
Just want to make sure that's on the record that this is a fiscally wise investment. And also it happens to be better for victims, and often will give us more quick and swift accountability. So anyway.
Yeah, and I'll just speak to in Chittenden County is where I'm most familiar with. The success rate of our 4 centers has been very high with pre-charge. It's generally from 70 to 90% for those who engage. So
tell me what success means.
Success means, that's a great question about restorative. As Willa said, the process is very similar no matter what stage of the system you're getting it from, pre-charge, post-charge, or reparative even after sentencing. The idea is that you are asking for accountability as a get-go. If somebody is denying their involvement and saying, I didn't even do this, they're not going to be an appropriate referral. So it's for those who are taking responsibility for at least some portion of the crime or that behavior, and reaching out to a victim or multiple victims, impacted parties, and seeing how or if they want to be involved in the case, presenting, the preparation is the most time-consuming part of any process, reaching out to both the impacted party, the responsible party, talking about what they are taking responsibility for or what they experienced as a victim, asking about what repair could look like, what has been impacted and who has been impacted, in what ways is restitution needed, what is the victim's wishes for repair, what would help make this right, and involving volunteers often in that conversation, community volunteers who also feel impacted by crime, even if not directly, and asking those parties at the table what would help repair this, and making an agreement, kind of a contract. And if that contract is successfully completed, that's engaged. I mean, that's successfully completed. That's what we call it. If they do the things asked of them in the contract that was developed collaboratively with the responsible party and the impacted party and the volunteers.
Other questions or statements made in the form of a question? Tom?
I have a suggestion, maybe, that both of them that you use. And probably Willa got really good arms for this, to just get involved with the Criminal Justice Council when they have a level 3 going on, and spend an hour with them and make them aware that this is going on. Then they'll know to look for it, and it'll spread pretty easily that way.
That's a great. Yeah, when we did have that DCF contract doing law enforcement training, one of the recommendations coming out of that was to get it into the training council for sure.
They towards the end, usually they have, it's kind of like their miscellaneous bill and training down there, where they have a lot of exposure from different departments, and you can go in and just make them aware. And if they know it's aware, they'll look for it and use it.
Yeah. And it might go without saying, but I probably should just say it, in that the pre-charge that we have historically done involves youth and adults. So this is with juveniles and adults.
Thank you very much. Before we break, just so everybody understands why we've even talked about this today, we are going to be looking back at various things that we've done over the last few years and just getting updates. But also probably sometime next week, we'll be discussing if we're going to make recommendations to the Appropriations Committee on the Budget Adjustment Act. And certainly I'm hoping to get support from hopefully the whole committee, that one of those priorities is to get that additional individual for the Attorney General's office to get this program up and running. We will later be talking about the budget and what the budget requests are. I'm hoping the governor will include that in the budget, but it's an Attorney General's budget that goes through the governor, and we'll be talking about that funding. And I am going to strongly urge that one of the priorities is to make sure that the pre-charge program gets up and running, for the reasons that I said in my not really a question. So I'm happy to talk to folks about that offline as well. Trevor, I'm sure will be happy to talk to folks as well. But it seems to be a really wise investment, and we will be hearing for other folks who are going to have asks of the budget that may or may not be in line with where the governor is one way or another. And I understand that as Republicans, that might be awkward if there is stuff that we want to push for as this committee, because we see it as very important. I know that state's attorneys will have them in here. The court, which I keep on hearing the court's not going to have any additional asks this year other than for technology, which I think is in the BAA, if I'm right, Trevor. But that's in part. So that's also in part why we're talking, and Matt Valerio, and the victims advocate. So we'll hear from them when we get to that point, because that's one of the things we do is we give the Appropriations Committee what we believe is a priority for out of the jurisdiction that we have. Did I get that? Anything?
Yeah, that's exactly the way I would put it.
Maybe a little different. But any comment, any input on that?
No.
Good.
Thank you.
All right. Okay. All right. So we'll adjourn until 1 o'clock. We have some in here training, a little